So welcome back. A good idea. Today I'm going to be talking about Aretha Franklin, the great singer. She is a really good example of this. My grandmother actually had a handwritten will too. But in Aretha Franklin's estate, she had two different handwritten wills. Those are called holographic wills. They're also legal in Tennessee. She had one done in 2010 that was locked in a safe in her house. And then she also had a 2014 will that was in a spiral notebook that was found in a couch. So there's a couple of stories here. Number one, handwritten wills create lots of ambiguity and uncertainty based on what did the decedent want. So in Tennessee, it has to be in the decedent's handwriting. It's got to be signed and dated. It's got to be proven by two disinterested witnesses. Almost always, they create litigation because some of the things were marked out. What did she actually mean by this? Who actually was intended to receive the house or to receive the insurance product or whatever the assets are. Lots of uncertainty, vagueness, and ambiguity, and they lead to very expensive litigation. The other lesson here in Aretha Franklin's estate, though, is that she had two. Not only did she not seek counsel and get an attorney to help her out with her sizable estate, she chose to do it herself. Now, softwares like LegalZoom and trustandwill.com are never a good idea either, but we most certainly don't want to use a handwritten will. She had two. And so anytime we have individuals, clients that come in, people that we know in the community that have done multiple wills, that's a problem, right? In this case, there were two different wills at two different dates. Courts came to different conclusions as to which will was valid. Her sons got involved in the litigation. And actually, just a couple of years ago in 2023, a jury trial was held in Michigan finding that the more recent will was valid, overruling the 2010 will. And so, her estate has been going on for years and years. And yes, this is a celebrity. But the important thing as a viewer to internalize is we see this in our local courts here in the Upper Cumberland, here in Tennessee. Uh, Litigating handwritten or holographic wills, litigating wills that were done at different times. Good lawyers can make very good arguments based on these instruments because they're vague and the person's dead. And so it's really important that if you go and update your will, you come back. Yes, you have to go see your attorney again, but it's really important that you either make a valid codicil or amendment to your prior will, or many times we advise just revoking the first instrument, revoking the first will, and creating a new last will and testament, okay? And with your attorney's help, that will make that very clear that the new will is the will that you intend to carry the day after your death in probate court. So again, this is the month of August. This is Make a Will Month, and it's really important because so many people do this, or I wouldn't be doing a video on it, right? They do their own wills, they go through Law Depot or something online, and we end up in a will contest. We end up in a capacity lawsuit. Did the individual have competency? Did they intend for it? Was it actually in their handwriting? Was it done under undue influence? You need to make sure that you go and seek counsel. You get those witnesses there that are disinterested. You get someone with a law license to help you through it. This is one of the most important decisions that you'll make, and you should make it in the month of August. So give us a call.